Things, global happenings today. We communicate, we analyze global news. Stay tuned.
Hello beautiful people, welcome back to Global Happenings Today YouTube channel. This is breaking and we have two in one. A quick recap: as some few years back, Emeka Ihedioha was removed. Emeka Ihedioha, the former governor of Imo State, was removed from seat by the Supreme Court. Fast forward, there was a lot of suits and there was a counter suit also filed by another candidate that insisted that Hope Uzodinma, the present governor of Imo State, had a double nomination and hence cannot and shouldn't actually have featured as an APC candidate, and therefore his candidacy and governorship annulled. Remember, that suit was supposed to be heard before the elections. Fast forward, the Supreme Court adjourned the hearing to yesterday. The verdict is out. You're going to get to find out in a moment how it went down. And of course, it looks like the Supreme Court case on Bola Ahmed Tinubu's presidency is not over yet, as there's another case coming up. Now the question is, how are we going to get justice? I wouldn't know. Keep glued as we give you two interesting news very quickly into one. Let us start quickly with Tinubu's case, who is facing another legal battle. Then we get to find out the verdict of and the fate of Ihedioha on this matter. Now, according to the news, the President Bola Ahmed Tinubu has been dragged before the Supreme Court for allegedly unlawfully presenting himself for inauguration as president, despite a pending legal action against the conduct of the 2023 presidential polls. Now, citing the doctrine of least pendings, a presidential candidate in the 2019 general election, Chief Albert Ambrose Oworo is asking the Apex Court to nullify the inauguration of Tinubu as the winner of the 2023 presidential polls. Oworo, a constitutional lawyer, contends that the presidential election which produced Tinubu was an exercise in frugality and illegal self-help, given his yet-to-be-determined suit against Tinubu and others at the Supreme Court. Now, the pending Supreme Court suit with number SC/667/2023 has Chief A.A. Oworo and Hope Democratic Party as appellants, while respondents are former President Muhammadu Buhari, AGF, INEC, Asiwaju Bola Ahmed Tinubu. Oworo is arguing that Tinubu's declaration as president by INEC is an affront to the Supreme Court and the established law by reason of least pendings, adding that since Tinubu is a party in the pending suit before the Apex Court, he ought not have been presented himself for the inauguration in respect of any presidential polls. Now, Oworo contested the 2019 presidential election in the platform of Hope Democratic Party (HDP) against former President Muhammadu Buhari and claimed to be adjourned winner of the poll against the declaration of Buhari by the Independent National Electoral Commission (INEC). Now, his suit is seeking an order of court to declare him as the adjourned and constitutional winner of 2019 election, and currently pending before the Supreme Court, was on May 18 this year voluntarily joined by Tinubu as an interesting party. Now, in a fresh motion on notice served on Tinubu through the chambers of Chief Wole Olanipekun, Senior Advocate of Nigeria (SAN), the ex-presidential candidate is also praying to the Supreme Court for an order restraining the respondent and particularly Asiwaju Bola Ahmed Tinubu from further operating the Federation account pending the determination and resolution of the constitutional question again the 2023 election. Now, in a statement issued in Abuja alongside the civil group Hope Africa Foundation in respect of the suit, Oworo contended that since Tinubu had become aware of the suit and had voluntarily joined as an interested party after fierce arguments of his lawyers, he had breached the doctrine of least pendings and his purported inauguration liable to dismissal. Now, the statement signed by Anwar Ibrahim, the national coordinator of Africa Hope Foundation, read in part, and I quote, "We want to place on record that Tinubu's claim to the office of the president is affected by the reason of his being least pendings. This is also because, having joined the pending suit on the subject of mandate absorption by Buhari, nothing ought to have been done until the final resolution of disputed issues. There is no doubt that the present act of self-help and claim to occupy the office of the president by any of the parties in this action is an act of self-help and violate the law and doctrine of least pendings, which is to to the effect that nothing should be done by parties to change or affect the subject matter before the court so as not to prejudice the existing adjoined acquired constitutional rights and mandate of Chief Oworo as the adjoined constitutional winner of the 2019 presidential election. It is on record that Asiwaju Bola Ahmed Tinubu, in recognition of the doctrine of least pendants and the existing suit on the issue of absorption of mandate between Oworo and Buhari, joined the ongoing proceedings then in Court of Appeal on the 18th of May 2023 before his purported inauguration over the 2023 presidential electoral debacle. He is bound to await the outcome of the proceedings and the already existing issue of absorption of constitutional mandate and entitlement to serve out the same by Oworo. Now, the implication of this by law is that the 2023 presidential election and the outcome which Tinubu was aware of before joining the suit is subsumed and dependent on the outcome of the existing legal proceedings on the subject of the already adjourned and yet to be served constitutional mandate of Oworo to serve out the term of office of the President of Nigeria as required by law. Our laws in this regard concerning the doctrine of least pendants has been well affirmed by the Supreme Court in the case of Peter Obi vs. Ngige Supra, as parties are to maintain and strictly observe the fact of the existence of pending suit and efficacy and potency of undermining a court jurisdiction and engaging in the act of self-help and a brazen absorption of candidate parties' mandate, subject matter in the pending case. There is no doubt that the act of the present All Progressive Congress APC led central government in practical terms are clear act of absorption. As law-abiding citizens, we urge the Nigerian exercise patience and the due and early resolution of this outstanding matter issues to know who truly is the authentic Nigerian president. Oworo, who claimed to be adjoined constitutional winner of 2019 presidential election, predicted his grieves against the inauguration of Tinubu on anybody who else as successor to Buhari on the ground that he is the constitutionally adjoined winner of 2019 election and has not spent his 4-year tenure as required by law. Among others, Oworo had insisted that Buhari was observing his tenure of office since 2019 because the Supreme Court has not determined his petition filed in 2019 in which he challenged the purported declaration of Buhari as election winner. The first suit was dismissed by Justice Inyang Edemekwo of the Federal High Court in Abuja on January 30th, 2023, prompting his movement to the Court of Appeal. And the Court of Appeal in Abuja on this part, on May 25th, in adjournment by Justice Jamal Tuka, who led a 3-man panel, had refused to stop the May 29 inauguration of Tinubu. Justice Tuka had held that Oworo engaged in gross abuse of court processes by filing a frivolous, vexatious, and irritating suit to provoke respondents, and he was meant to pay some money. But let's find out the fate very quickly. The fate of Inyedioha. Now, this is what is thriving right now on social media. Now, the Supreme Court has dismissed a plea by Meka Inyedioha of the People's Democratic Party (PDP) in Imo State, seeking a certificate of return as the state lawful governor. Now, Inyedioha had told the Apex Court that Governor Hope Uzodinma was not qualified to run for the election in the first place, claiming that Uche Nwosu was earlier declared by the court as the rightful candidate of the All Progressive Congress APC. In a verdict read by Justice Tijani Abubakar today, the Supreme Court dismissed the motion for lack of merit, calling it needless and vexatious. Now, it awarded the cost of 40 million naira against Mike Ozekhome for bringing the matter before the court, because he actually engaged in services of Mike Ozekhome. And now 40 million naira is going to be paid by Mike Ozekhome. I'm sure Meka Inyedioha will be able to look into that. So you can now see the drama playing out in our courts. It's up to us. Let's put in that comment section.